Good evening, everyone. I'm back, like I told you I would be. Got some rest, so hopefully I'm not as rummy and goofy as I was earlier. It is Monday, November 17th, 2025, and um, Judge Elmore and her court history or trial history of appeals and whatnot. It seems like she's got quite the history of her just being appealed, and it seems as though quite a few of them are upheld or not upheld, and new trials are being given. So I don't know if she's needs to retire or if she's just a terrible judge. But we're going to finish with the Nelson appeal and find out what happened with that one. And then we're going to cover a couple of other stories that she's involved in. And it doesn't bode well for her. She just seems like she needs to, this isn't the line of work for her from what I can see. But anyway, you guys can make your own opinion. So let's get into it. Now, for those of you that don't know, Elmore is the judge for the Aaron Spencer case, and Aaron Spencer is the father who has been charged with murder because he found out that his 13-year-old daughter was being raped and essayed by a 61-year-old man named Michael Fossler. And he didn't confront him or anything. He was going through the right channels. Reported it to the police with 43 felony counts of different types of child essay. And he was out on, I think it was $5,000 bail, cash bail by Judge Elmore, of course. And he had a no contact order for her. And one night, her dog was barking, and her mom woke her dad up and said, "Can you go check on her? Maybe she's sick. Her dog doesn't usually bark like that." And he opened their bedroom door and she was gone. So he automatically freaked out, told his wife to call 911, and he got in his truck and went looking for her. He was worried, of course, because she was the only witness in his trial, Fossler's trial. And without her, there's no case. So what do you think he was going to do? Do you think he was going to bring her back home? I don't think so. Anyway, her dad, Aaron Spencer, was driving down the road, and he passed Fossler going the opposite direction with his daughter in the passenger seat. It was like 1:30 in the morning, I think. So he turned around and followed him, flashed his lights, honked, and Fossler wouldn't pull over. So I believe he nudged him with his truck. If I'm not correct, you guys can fix that for me. And Fossler went into a ditch. Aaron Spencer got out. Fossler got out, and Fossler was approaching him with something in his hand. So Aaron Spencer unloaded on him, filled him with lead, and then pistol whipped him in the face. Also, when Aaron Spencer got out of his truck, he was trying to get his daughter out, and Fossler was holding on to her. He wouldn't let her get out. So, I mean, that's kidnapping at its finest. So, Aaron Spencer did what any father would do, I would think. So now he's being charged with murder. Go figure. So, and Judge Elmore is also the judge who let a 19-year-old rapist out on bail, and while he was out on bail, he reoffended and was just arrested, I think October 25th, for the same thing, rape of a minor and sexual indecency, computer CA or sorry, CSA. So anyway, she's got quite the checklist going off with court cases that don't bode well for her. I don't know why she's got her hands in so many cases. She's in civil cases, she's in criminal cases. I don't know why they must not have very many judges there. I know it's a small county, but still, it's kind of crazy to think that she's involved in so many cases. And she's got a terrible judge of character, apparently. So I have to prove I'm not a robot. So just one second. I did check the new one. What are you talking about? There's a sidewalk there. Or a crosswalk. Oh my gosh. Doesn't believe that I'm human, apparently. Bicycle. Bicycle. I can't even tell if there's bicycles in there. Oh my gosh. I have to keep proving I'm not a fucking robot. This is insane. Oh my god. The fuck is that happening? Oh my god. Why does it keep doing this? Okay, we're gonna go back and try again. This is fucking crazy. Okay. That was insane. Why am I not sharing my screen? Shit. I thought I was going to do better tonight. Sorry, guys. Where's my StreamYard? There we go. Share screen. Share screen. There we go. Okay. Sorry. Okay, so where were we on there? Let me see. We're way past that. Jacqueline. Okay, the Jacqueline Ferguson. We had just finished talking about her court because he used her trial as case law in his appeal. So here we go. The court's majority decision to reverse on Judge Elmore's refusal to recuse herself was predicated on only one thing: the fact that Judge Elmore found that Is that JF? JF's questioning of her impartiality required her to withdraw as the finder of fact, in essence. Demonstrates that, I'm sorry, to withdraw as the finder of fact, in essence, demonstrates that the questioning of Judge Elmore's impartiality was reasonable. Ferguson, 2016, Arkansas, 319. Thus, despite JF's arguments that the court's holding implicated only Rule 2.11a, A's component of reasonably questioned impartiality, but not the personal knowledge factor of Rule 2.11, or the element that a judge presided over the matter in another court. In fact, the majority specifically rejected JF's argument that the knowledge Judge Elmore acquired in a judicial, I can never say that word, judicial proceeding, i.e. the DN adjudication, is the personal knowledge that would require disqualification pursuant to Rule 2.11. Basically, she should have recused herself because she had personal knowledge from a prior court case that she presided over. Despite the concurrence stating that Judge Elmore's presiding over both the DN proceeding and the criminal case should have implicated Rule 2.11's prohibition against a judge presiding over a case when she has already presided over the matter in another court. That's what I just said. That matter being the abuse of JF's child. That is neither binding precedent nor is that what happened here. Thus, the concurrence upon which Nelson improperly relies is inappropriate to this case. Footnote 4, a judge shall disqualify herself in any proceeding in which the judge has a personal bias or prejudice concerning a party or party's lawyer, or personal knowledge of facts that are in dispute in the proceeding. Here, while it is true that Judge Elmore signed a written termination order involving Nelson, she did not preside over the adjudication. Another circuit court judge did. And thus, she did not hear any testimony of witnesses, weigh any evidence, or make any factual findings. Furthermore, the DN proceedings, does that stand for Nelson? The DN proceedings here were for the circuit court to determine whether Nelson's daughter, MC2, should be adjudicated as dependent neglect, whereby Nelson's parental rights could be terminated. The criminal charges, however, were based on Nelson's alleged abuse of Chelsea's son, MC1. Finally, despite a different judge presiding over the adjudication, a factual determination in the DN case regarding Nelson's actions was ultimately unnecessary, as Nelson eventually consented to the termination. Because he voluntarily relinquished his parental rights to MC2, that eliminated the requirement that any judge make a finding of fact that Nelson committed child abuse of either MC1 or MC2. Judge Elmore specifically noted her only finding was that the child was adoptable. This case was decided by a jury at Nelson's request. Judge Elmore did not preside over the DN adjudication, and unlike the facts in Ferguson, Nelson did not allege any bias or prejudice that would have led Judge Elmore to the conclusion that her impartiality might have been reasonably questioned. In light of the circuit court's specific consideration of the applicable law, we cannot say the refusal to recuse under Rule 211 was an abuse of discretion. So basically, they did not find in favor of Nelson for his appeal, okay? So okay, so we'll keep going. This is a long one. Batson challenge. In his third point, Nelson asserts that the circuit court erred by overruling his Batson objection to the state's peremptory strike of veneer member Marcy Anderson. Specifically, the basis of his objection was that Miss Anderson was the only person of color who appeared on the panel. Thus, the state has struck one of one. I don't know what that means. Struck one of one. Pursuant to Batson versus Kentucky, 476 U.S. 79 in 1986, the state in a criminal case may not use its peremptory strikes to exclude jurors solely on the basis of race. Jackson v. State, 375 Arkansas, 2009. Once a challenge is made, the circuit court must conduct a three-step inquiry to determine whether a Batson violation occurred. McMiller v. State, 2014 Arkansas, 416. First, the opponent of the peremptory strikes must present facts to make a prima facie case, I'm not sure if I said that right, of purposeful discrimination. Second, upon a showing of a prima facie case of systematic discrimination, the state is required to give a race-neutral explanation for the strikes. Unless discriminatory intent appears in the prosecutor's explanation, the reason given will be considered race-neutral. Third, the circuit court must decide whether the opponent of the strike has proved purposeful discrimination. On appeal, we will not reverse a circuit court's findings on a Batson objection unless the decision is clearly against the preponderance of the evidence. Some deference is accorded the circuit court in making this decision because it has the opportunity to observe the parties and determine their credibility. I don't think any of these fuckers have credibility, if you ask me. They're all a bunch of whack jobs. After the defense's Batson challenge was made, the following exchange occurred. The court, okay, why did you strike Miss Anderson? Prosecutor, didn't like her answers, and she seemed like she didn't want to be here. And so we thought that she would not be and would not be a good juror, that she wouldn't pay attention. She just seemed annoyed by being here for answers and by her demeanor. Defense counsel, Your Honor, our response would just be that I think that describes a majority of the jurors that were on the panel and are sitting out in the crowd. Court, yeah. Defense counsel, not unique to her. The court, I agree with that. I think that they had a valid reason to strike Miss Anderson. Defense counsel, yes, Your Honor. The court, and I don't see that race is a problem in this particular case, especially. Hereafter, defense counsel objected to the striking of Anderson. The state gave a race-neutral explanation, which the circuit court accepted as valid. As the defense failed to prove purposeful discrimination, and because we defer to the circuit court as the arbiter of credibility in its superior position to observe both Anderson's level of interaction and the prosecutor's demeanor in asserting its race-neutral reason, we hold that the circuit court's decision to deny the Batson claim is not clearly against the preponderance of the evidence, and we affirm on this point. So he lost that appeal too. Not appeal, but that part of his appeal. There are quite a few numbers to his appeal. Now the voir dire regarding sentencing. Nelson's fourth argument, that's what I meant to say. Nelson's fourth argument on appeal is that the circuit court abused its discretion by improperly restricting Nelson's questions about potential sentences during the voir dire. The extent and scope of of voir dire examination of prospective jurors falls within the circuit court's sound discretion, and the latitude of that discretion is wide. Accordingly, we will not reverse voir dire restrictions unless the discretion is clearly abused. An abuse of discretion occurs when the circuit court acts arbitrarily or groundlessly. The judge shall initiate voir dire by identifying the parties and their respective counsel, revealing any names of prospective witnesses, and briefly outlining the nature of the case. But beyond these four requirements, counsel may ask additional questions only, quote, as the judge deems reasonable and proper, end quote. We will not reverse for non-prejudicial errors in jury selection. For support that the circuit court abused its discretion, Nelson cites Dillard v. State, Arkansas 491 in 2005. In Dillard, when the defense counsel asked the jury panel whether anyone was uncomfortable with the penalty range being 10 to 40 years or life in prison, the state objected. The court sustained the state's objection and said counsel could only ask whether the panel could consider the full range of penalties, but could not tell the jury what the range was. We held that the court abused its discretion because counsel was permitted to determine, quote, whether the jurors could consider the term of years for aggravated robbery provided by law, end quote. In reaching this conclusion, the Dillard court examined three earlier cases, Haynes v. State, Stevens v. State, and Felty v. State. In Haynes, we reversed a conviction after determining the state's, quote, whole line of questioning, end quote, revealed the intent to impanel a jury that would vote for the maximum sentence upon a finding of guilt. Just 1 second, I'm going to get a drink. The court noted that, well, let's look at number 5 footnote first. Ultimately, the court did not reverse. However, because the defendant was sentenced to the statutory minimum sentence, and thus the court found no prejudicial error. Okay. The court noted that the purpose of selecting a jury is to obtain a panel that would be fair and impartial to the accused as well as to the state. After recognizing that several members of the veneer were excluded because they expressed reservations about assessing the combined maximum possible sentence, this court held that because the members of the jury were, quote, were not chosen upon their promise to consider the full range of penalties provided by law, end quote, and because of the unfairness of the type of questions presented to the veneer, the questions clearly constituted prejudicial error. In Stevens, after stating the minimum and maximum penalties for the crimes charged, the state asked the prospective jurors whether they would consider the maximum penalty. We held this to the permissible as, quote, the jurors were asked only whether they would consider all the penalties provided by law, end quote. As opposed to the Haynes jury being asked to commit a possible penalty or to express an opinion on whether such a penalty would be suitable. In Felty, the prosecutor informed the veneer that the defendant was charged with 2 counts of a Class Y felony, which carries from 10 to 40 years or life. Quote, is there anyone here, if they found that the defendant committed these acts, that could not sentence him to a long term in the penitentiary, end quote. We again held it was permissible for the state to ask the jury whether it could impose the maximum sentence. Nelson was charged with first-degree domestic battery, which by law allows for potential fine not exceeding $15,000, a prison sentence of not less than 5 years or more than 20 years in the Department of Correction, or both. Unlike in Dillard, the defense did not propose to give the specific penalty range and ask if the panel was uncomfortable considering it. In fact, the record is void of the aforementioned penalty range during either party's arguments regarding voir dire. Here, an entirely different line of questioning prompted the state's objection. Quote, "Do you think a felony conviction is a punishment in and of itself?" End quote. In the bench conference, defense counsel explained to the circuit court that he wanted to ask the jury, quote, whether they would consider a fine only for a felony offense, end quote. Despite his argument on appeal, Nelson was not prohibited from inquiring whether the jury was comfortable with the sentencing options for the charged acts, because that is not the question he offered. Ultimately, the circuit court stated that the defense was permitted to ask the jury if they could abide by the instruction of the law. Quote, "All you have to do is if we have the instructions from the court, can they follow the instructions?" End quote. They were permitted to ask, quote, "from the minimum to the maximum. That's it." End quote. Counsel for both the state and Nelson resumed questioning without further inquiry of the circuit court into permissible questions. Notably, neither party asked another question pertaining to sentencing. Although our case law holds that it is not an abuse of discretion for the circuit court to allow the state to ask whether jurors could consider a statutory maximum penalty, it does not in turn hold that the circuit court does abuse its discretion by preventing defense counsel from asking whether jurors would consider the minimum punishment for a felony offense when the entire range of punishment is not offered. Ultimately, the latitude on whether the circuit court allows extensive voir dire about punishment is within the court's wide discretion. It was within the circuit court's purview whether to restrict a specific question, asking the panel to commit to the minimum punishment prior to the hearing of evidence. The court previously cautioned that allowing questions aimed to qualify jurors for a specific punishment prior to the presentation of the case will not only result in the inevitable pursuit of the accompanying challenges for cause, but would also lead to the trial process becoming greatly burdened and expanded in time and expense. In light of the foregoing, it cannot be said that the circuit court acted arbitrarily by restricting Nelson's voir dire questions. Thus, we hold that no abuse of discretion occurred. Additionally, as was noted by the circuit court in Dillard, defense counsel announced the jury was acceptable to the defense and identified no juror who had been prejudiced by the circuit court's ruling. In fact, verdict from AMI Crim was given and specifically listed the full range of the permissible sentences for Nelson's crime. The jury came back with a sentence on the lower end of the spectrum, 8 years. Although this was not the statutory minimum sentence, as in Dillard, it was an intentional sentence specifically chosen by the jury panel to fit Nelson's conviction based on the evidence presented. Because Nelson fails to demonstrate how any member of the seated jury prejudiced the verdict, we affirm. Okay. I'm just looking to see. How many more pages? This is quite long. Jesus Christ. So there's 24 pages, and we are on page. Holy shit. Let me see. Sorry. Potty mouth. We are on page. We are not anywhere near that. I know that. Sorry, my son's here giving me moral support, telling me what I'm doing wrong. I'm kidding. So where are we? We are nowhere near page 24, but we'll keep going. We're okay. We're on page 16. Okay, inadmissible under either ARC. Okay, I didn't read that part yet, though. Okay, I don't know what EARC-R EVID is, but we will read it. For his fifth argument, Nelson argues that the circuit court erred in admitting 3 segments of Chelsea Spadowski's testimony because he claims the statements were inadmissible under either ARC-R EVID or ARC-R EVID 403, 404B or 403. And 404B again. Oh, sorry. 404B states evidence of other crimes, wrongs, or acts not admissible to prove the character of a person in order to show that he acted in conformity therewith. It may, however, be admissible for other purposes, such as proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. Evidence is not admissible under Rule 404B simply to show a prior bad act. Rather, the test for admissibility under Rule 404B is whether the evidence is independently relevant, which means it must have a tendency to make the existence of any fact that is of consequence to the determination of the action more or less probable than it would be without the evidence. Evidence of circumstances that explains the act, shows a motive, or illustrates the accused's state of mind may be independently relevant and admissible. Lee versus State, 327 Arkansas, 1997. A circuit court's decision to admit evidence is entitled to great weight and will not be reversed absent an abuse of discretion. Abuse of discretion is a high threshold that does not simply require error in the circuit court's decision, but requires that the circuit court act improvidently, thoughtlessly, or without the due consideration. Footnote 6. The record demonstrates that Nelson sought exclusion of the evidence at issue pursuant to Rule 404B and argued relevancy, but as to the second and third objections, he did not assert that the evidence should be excluded pursuant to Rule 403B. This argument was not presented to the circuit court, and therefore we do not reach the issue on appeal as it relates to these 2 objections. Here, Nelson claims the circuit court abused its discretion by permitting the state to introduce evidence about, 1, Nelson's status with his ex Chelsea that created an inference Nelson was dating 2 women at once. And 2, Nelson's prior discipline of the children in his home. And 3, Nelson's turbulent communications with his ex, Brandy. How many? So that's 3 exes all in one sentence. Does he have kids with all 3 of them? And he's only in his 30s, I think. Wow. Of course, there's not much else to do in this county, I don't think. It's a really small county, so they could all even be related. I'm just kidding. That's not very nice. Anyway, he contends the evidence should have been excluded because it had no independent relevance. The first objection stemmed from a question posed to Chelsea regarding Nelson's relationship status with his daughter's mother, Brandy. At the time Chelsea moved in with Nelson. Was Nelson divorced from his MC2's mother, or were they separated? Do you recall? End quote. Defense counsel argued that Nelson's status with Brandy was irrelevant as to whether he committed the battery. Quote, it's not relevant at all. It's 404B, prior bad acts. I mean, adultery is a bad act. However, upon a review of the record, Chelsea's testimony contains no such inference of adultery as indicated by Nelson. So she doesn't think he committed adultery, but he does. That's weird. Usually it's the other way around. Usually the guy's denying it. Anyway, as the record is void of testimony alleging a prior bad act existed, no further analysis of exclusion under Rule 404B is required. Additionally, because the testimony contained no unfairly prejudicial information, the circuit court did not abuse its discretion in denying the motion to exclude pursuant to Rule 403. The second objection arose when Chelsea was asked about Nelson's discipline of the children when he was angry. We all know what happened to her son. Defense again argued the same objection relevance. Ultimately, Chelsea testified that Nelson spanked a little harder when he was angry. Well, no shit. And would yell or raise his voice when speaking to the children. Okay, well, that's who doesn't? The third and final objection occurred when Chelsea was prompted to describe Nelson's reactions to telephonic communications with Brandy, to which her testimony was, what's telephonic communications? No, I'm kidding. Sorry. That's mean. Anyway. To which her testimony was that Nelson would get mad and storm off into the bathroom and shut the door and sit in there after receiving texts or calls from her. In response to each objection, the state maintains the evidence was independently relevant as to Nelson's state of mind on the day of the incident, as well as evidence of intent and absence of mistake or accident. Specifically, Nelson's defense to the battery charge was that MC1's injuries could be the result of an accident. This defense triggered the admission of evidence by the state to rebut his defense. Further, because Chelsea testified that Nelson was on the phone with Brandy prior to her leaving for work the morning in question, it was proper to admit evidence as to Nelson's state of mind. Thus, the evidence was not offered to show the bad character of Nelson, as he contends. Just one second. Thus, the evidence was not offered to show the bad character of Nelson, as he contends. Rather, the evidence was independently relevant proof of Nelson's state of mind and the absence of mistake or accident in committing the offense. As the decision to admit the evidence was not done thoughtlessly, the circuit court did not abuse its discretion. Accordingly, we affirm. F. Exclusion of the juror. Nelson's 6th point on appeal is that the circuit court abused its discretion by refusing to strike juror Leach for cause. Nelson contends Leach, quote, made clear, end quote, that her prior relationship with the witness would afford him more credibility than the other witnesses. Thus, the court's failure to excuse her as a juror was erroneous. Are you shitting me? She was a juror and she had a prior relationship to one of the witnesses in the case? Wow. Isn't that a conflict of interest? That's okay. You can't make this stuff up. A juror is presumed to be unbiased and qualified to serve, and the burden is on the appellant to prove otherwise. Smith v. State. It is for the circuit court to decide whether a juror is qualified, and that finding will not be reversed absent a showing of abuse of discretion. We have held that the appellant must demonstrate prejudice in arguing that a juror should have been removed. The burden is on the appellant to prove that a reasonable possibility of prejudice resulted from juror misconduct, and prejudice is not presumed. Whether prejudice occurred is also a matter for the sound discretion of the circuit court. Here, the issue came up in the middle of trial before the calling of state witness Matthew Thomas. Prior to Thomas taking the stand, the bailiff made the circuit court aware that juror Leach potentially knew the witness from her church. In response to such information, the court asked about the juror's ability to remain impartial. While Leach initially stated she would give Thomas's testimony more weight than a witness of whom she had no personal knowledge, she ultimately, that's affirming that she's not impartial. She's saying she's going to give his testimony more weight than other testimony. That's not showing impartiality. Oh my God. Oh Lord. She ultimately affirmatively stated she could make her decision based solely on the evidence presented at trial. When asked if making a decision contrary to Thomas's testimony would make her uncomfortable, she replied that it would not. My uncertainties that might arise from the juror's response can be cured by rehabilitative questions. Thus, the court appropriately determined Leach was an acceptable juror and did not abuse its discretion. Moreover, Nelson did not and cannot prove the prejudice required for reversal. Thomas was an undisputed fact witness only. Not a single portion of his testimony revolved around whether Nelson committed the crime for which he was charged. As Thomas's credibility was in no way questioned, Nelson accordingly cannot show how Leach's remaining on the jury made a difference in Nelson's guilty verdict. Therefore, we hold that the circuit court did not abuse its discretion in refusing to strike the juror, and that Nelson had failed to demonstrate that he was prejudiced by the circuit court's refusal, and thus we affirm. G, limitation of expert testimony. For his final point on appeal, Nelson argues the circuit court improperly restricted his expert's testimony as to causation of MC1's injuries. Arkansas Rule of Evidence 702 provides that if scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact in issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of an opinion or otherwise. Kind of like Man Shannon in Karen Reed's case. He thought he was an expert. The test of qualification as an expert is whether, on the basis of the witness's qualifications, he or she has knowledge of the subject at hand, which is beyond that of ordinary persons. Whether a witness qualifies as an expert in a particular field is a matter within the trial court's discretion and we will not reverse such a decision absent an abuse of that discretion. The state moved to exclude the testimony of neuropsychologist Dr. Garrett Andrews on the basis that he was not a medical doctor and was not equipped to make medical findings. After careful consideration, the court permitted Andrews to testify but limited his testimony upon a finding that his practice as a neuropsychologist concentrated on treating the effects of traumatic brain injuries rather than determining their causes. The court stated, quote, he's not going to do a medical diagnosis on the child, end quote. On the child, because that's not really his expertise, end quote. Simply put, Andrews was permitted to testify that he had previously treated brain injuries caused by accidents, but he could not opine that MC1's injuries specifically were the result of an accident. MC1 is child 1. They use the initials, they don't use the names of minors. Notably, the circuit court allowed Andrews to testify in exactly the manner in which Nelson proffered before the trial, that he would testify, quote, about his expertise and the different causes of these kinds of traumatic brain injuries in general, end quote. Nelson specifically offered the limitation that the circuit court ultimately imposed, suggesting the court could narrow the scope of Andrews' testimony to avoid challenging Dr. Klingenpill's diagnosis of child abuse. Nelson now argues that the fact that Andrews did not personally meet MC1 should not have disqualified him. Quote, as Andrews reviewed the relevant medical records and was prepared to give an opinion based on that review and his personal experience treating such injuries, end quote. Emphasis added. Thus, even Nelson admits that Andrews' expertise was in treatment, not diagnoses. It was therefore not an abuse of discretion for the circuit court to determine that Andrews lacked the specialized knowledge of causation of MC1's injuries and to prohibit him from testifying as to whether MC1's injuries were caused by an accident. As an alternative to the complete disqualification of Andrews, his only expert witness, Nelson moved for a continuance to obtain a medical doctor who could speak to causation. Quote, the circuit court shall grant a continuance only on a showing of good cause and only for so long as is necessary, taking into account not only the request or consent of the prosecuting attorney or defense counsel, but also the public interest in prompt disposition of the case, end quote. The general standard of review for granting or denying a motion continuance is abuse of discretion. In denying Nelson's motion for continuance, the court made clear that this case was approximately 3 years old and what defense was requesting, quote, should have been done a long time ago, end quote. Ooh, ouch. Well, they didn't know that they weren't going to approve of Thomas's testimony, I don't think. Additionally, at the time Nelson argued for a continuance, Nelson believed Andrews, not Thomas. Andrews was precluded entirely from testifying at trial. However, as the circuit court subsequently granted Nelson's motion for reconsideration and allowed Andrews to testify consistently with Nelson's proffered testimony at the pretrial hearing, no such prejudice resulted from the denial of a continuance to obtain a different expert. Neither the limitation of Andrews' testimony nor the denial of Nelson's motion for a continuance resulted from an abuse of discretion warranting reversal. We affirm. Oh my God, we're almost done. Whew. This is the longest one I've ever read, and I don't know why. It's not that boring, but it is boring for some reason. Okay. Roman numeral 3, case or cross appeal by the state. The state appeals from the circuit court's ruling directing a verdict on the sentencing enhancement pursuant to Arkansas Code and 2019. The state argues the circuit court misinterpreted the statutory phrase, quote, in the presence of a child, end quote. Before we address the merits of the state's arguments, we must determine whether this is a proper state appeal pursuant to Rule 3 of the Arkansas Rules of Appellate Procedure Criminal. The state's right to an appeal is limited. This court has consistently held that there is a significant difference between appeals brought by criminal defendants and those brought on behalf of the state. The former is a matter of right, whereas the latter is neither a matter of right nor derived from the Constitution, but rather is only granted pursuant to the confines of Rule 3. We accept appeals by the state when our holding would be important to the correct and uniform administration of the criminal law. As a matter of practice, the court has only taken appeals, quote, which are narrow in scope and involve the interpretation of law, end quote. The court does not permit state appeals merely to demonstrate that the circuit court erred. We dismiss those appeals that do not present an issue of interpretation of the criminal rules with widespread ramifications, and those appeals in which the resolution of the issue turns on the facts unique to the case or involves a mixed question of law. When an appeal merely raises an issue of the application, not an interpretation of a criminal rule or statutory provision, we deem it to not involve the correct and uniform administration of the criminal law, and thus not within the ambit of permissible state appeals under Rule 3. The state claims, basically, the state can't appeal just because they want to appeal. There has to be extenuating circumstances to cross appeal. The state claims that the instant appeal involves an issue purely of statutory interpretation that is not dependent upon the facts of the case, but that, quote, involves an issue with potential widespread ramification, end quote, and that such an opinion from this court would help maintain uniformity throughout the state. I'm getting tired of saying quote, unquote. Holy crap. And, quote, provide guidance to circuit courts faced with similar circumstances, end quote. The state frames the issue on appeal as whether, quote, the circuit court misinterpreted the statutory phrase presence of a child, end quote, and wrongly found that to prevail on the sentencing enhancement pursuant to Arkansas Code, and the state had to prove that Nelson's own child actually heard or saw the battering. Well, if he was standing right there, how could he not see it? Pursuant to Arkansas Code and, quote, in the presence of a child, end quote, means in the physical presence of a child, or knowing or having reason to know that a child is present and may see or hear an act. By the state's own argument, the circuit court committed error by, quote, reading the word may out of the statute and substituting an atextual requirement that the state prove that a child actually see or hear the battery, end quote. Thus, while the issue presented in the state's appeal might appear at first glance to involve the interpretation of statutory language, what the state raises is actually an issue of application rather than interpretation. It is clear that the circuit court based its decision to grant Nelson's motion for directed verdict as to the sentencing enhancement on the specific factual or evidence presented at trial. The circuit court specifically said there was insufficient evidence that Nelson's daughter saw or heard the battery. Quote, in this case, I have nothing but pictures. All the evidence I've received of the house, nobody's told me anything about the size of the house or anything else. I believe MC squared was there, but there's nothing here that tells me she heard it or saw it, end quote. Upon review of the circuit court's language in its bench ruling, the directed verdict on the sentencing enhancement was based on the unique facts of the case before it. While we understand the state desires a declaration that the circuit court misapplied the statutorily defined phrase, quote, in the presence of a child, end quote, to the circumstances of this case, because the state's argument presents a mixed question of law and fact, and because we do not permit appeals merely to demonstrate error of the circuit court. We hold the correct and uniform administration of criminal law does not require this court's review pursuant to Arkansas Rule of Appellate Procedure Criminal, and dismiss the appeal. Jesus Christ, you can't have run-on sentences like that when you're in school. Why can you do it in court? That, I mean, it just like goes on and on and on. You forget what you're even talking about by the time you finish the sentence. If you run out of air while you're reading a sentence, the sentence is too long. Can I just say that? Affirmed on direct appeal, cross appeal dismissed. Okay, so now I want to show you what happened. So Nelson wasn't going to settle for this, and he was like, hell to the no, we're going to appeal that appeal, right? So they sent it up to the Supreme Court, the Arkansas Supreme Court, and let's see what happened there. They got their butts chewed a little bit, and they had, like, the University of Arkansas even got involved with. They were even wrote a little case, not case law, but wrote a little something up on it too, and it's like crazy. It says, where is it? It says something like confusion and where'd it go? Not this again. We'll find it. I'll find it. I swear. Right. No, that's not it. Yeah. Is it? Okay. I think I found it. If not, it's close enough. Right? Right. Let me see. Yeah, it's small. I need to go get my eyes checked so I can get some new contacts. I'm out of contacts. They won't refill it. No, that's not the right one. Ah! That's not it. Sorry. Patience. Be patient. I promise I'll find it. Supreme Court. They're like interweaving Aaron Spencer's gag order, Supreme Court gag order stuff into my search, and I don't know why, because it has nothing to do with this case, but whatever. This is going to piss me off if I can't find it. Like earlier today when we were looking for that guy's, the article on that Wesley Hannard's arrest for raping a girl while he was out on bail for rape. It's like, what the fuck? Why does all my shit keep disappearing? I don't understand. feel like it's, I don't want to be a conspiracy theorist, but Jesus Christ, it's almost like there's always something missing. I look up something and then I go to get it the next day because I don't want to download everything to my computer. I won't have any room on my computer. Right? So you just want to look it up the next day on the same thing and then it's never there. What the fuck? Okay. I'm about ready to go postal. I don't have patience for shit like this. This is where I just turn off the computer and say fuck it and go to bed. But I can't do that now because I'm on a live stream. If I were recording it, I could just hit pause and go to bed and wake up happy and pick up where I left off. But I'm doing a live, so I can't very well do that. And I can't blame it on getting any sleep because I slept for a couple hours now. So shut up and just look it up, Wendy. Okay. Supreme Court. It's really funny because the name of the article is even like confusion and misleading or something like that. And I was like, oh boy, that doesn't sound good for them. And now I'm not finding it. And that's really going to piss me off. Oh my gosh, this is going to piss me off. Can you find it? Can you find backpack? Everybody backpack. Oh, here we go. Told you. I told you I'd find it. Okay. Okie dokie. Okay, this is from the University of Arkansas at Little Rock. It says judicial disqualification. Let me see. Sorry. Make it bigger for y'all. Okay, that's not working for me. Why is it doing that? This is what happened earlier, huh? It's happening again. I don't know why. Layout. Everybody backpack, backpack, backpack. Everybody backpack. Is that what it is? Is that how it goes? Something like that? I don't know. Fuck it, we don't have any chatters, so we'll just take up the whole screen. See if that helps. No, it doesn't. Oh my god. Ha! That's big. A little. Okay. I just want to share screen. That's all. And it says I'm sharing. So what's the problem, Wendy? But I'm not sharing. There's nothing showing. Why is it not showing anything? Oh. There we go. Ha! Told you I could do it. I just got from there. Okay. Judicial disqualification Confusion. Is it showing on you guys? No, what happened? Fuck. There. Jesus Christ. There. Add screen. Share screen. There. It's not showing. Why is it not showing? There we go. Now I just have to make it big enough so my blind ass can see it. Okay. Judicial disqualification, confusion, clarification, and continued considerations. A closer look at Arkansas's judicial disqualification rules in light of Ferguson v. State. Oh, God, how long is this? Holy shit, this one's 24 pages too, also. Let's just see. Let me just look through it real fast, and maybe I can just pull out the big stuff. I guess I don't have to read all the footnotes because those look really confusing. I can just read the body. Oh, God. Let me see. Because it's going to give you the whole case background like the other one did, and we know the case backwards and forwards by now, right? God, look at all the footnotes. There's more footnotes than there is body to the document. I mean, Jesus, Lord mercy. Let's just see what they ruled. How long have we been going? It's been a while, huh? So we're all tired of hearing my voice, I'm sure. So let's just get down to the nuts and bolts, or brass tacks, or whatever that saying is. Argument. Jesus Christ. I don't think I could be a lawyer, just writing all this stuff over and over and over and over and over and over. What was that? Okay. And the court affirmed Judge Elmore's denial pending. The dissenting justices pointed out whether the case were in fact the same. I want to just get down to basically the results of all this. I think he wins. I'm almost certain of it. But I don't want to say that prematurely, because we all know what doing something prematurely does. It doesn't work so well for people. Jesus Christ. This is like some heavy duty crap. That's why when we were watching the Karen Reed case, they said Melanie was saying how hard being an appellate lawyer is, because they have all this shit they have to write. I mean, you see all those footnotes? Holy crap. Okay, wait. We got to the end and I didn't see it. Yeah, no sense. Okay, you're not going to believe this, but that's not even saying what I needed to say after all that. So, frick. I know he wins it because it says that he got a new trial was set forth. I just have to find where it says that. You know? So I can be vindicated that I was right that it said that. Oh, God. It's hot in here. My heater just went on and it's freaking hot. That's not even the right case. Jesus, why are they giving me cases that I'm not even looking up? Oh my God. Okay, we're gonna find it. I promise, I promise, I promise. Is this it? Ferguson versus State. Supreme Court of Arkansas. Jacqueline Ferguson, appeal from the Lone Oak. This is for Jacqueline's one, though. Oh, maybe she's the one that won the Supreme Court appeal. Let's see how many pages this fucker is. Jesus. 16? Well, we're not going to go through all of it because we already went through her case earlier today, remember? So we don't have to go through all of this again. We will just go straight to the ruling of the Supreme Court because when she took it to the appellate court, when she appealed, the appellate court did not rule in favor of her. The appellate court reaffirmed Judge Elmore's decision, remember? So they took it to this Arkansas Supreme Court, and it was overturned and remanded for a new trial, which is insane. How embarrassing for Judge Elmore. But I just have to find where it says because remember, this is the one where she waived a jury trial, and the judge said, well, if you think I'm biased or prejudiced, then I'm denying you the waiver. And it's like, okay, well, that only confirms the bias and prejudice. I mean, duh. I don't know. These people are backwards. But who am I? I'm not a lawyer, so maybe they are smarter than me in that sense, I think. How would I know? I don't know the law. Jesus Christ. What page is this? 7? Oh, we're only on page 7. What the hell? Where's the ruling? I just want the ruling. Yeah, this is basically what I read this morning, only it's written by the Supreme Court rather than the appeals court, but it's the exact same wording and everything. It's like just a blot. I mean, talk about a waste of paper. They go through. No wonder there's so much logging in Arkansas and Kentucky and those places, because they do a lot of appeals apparently, and they need all the paper. Crazy. What page? Okay, that is page 4. Jesus. Is it taking a long time or is it me? I thought it said that this one was 24 pages also, but I didn't see that. She denied the motion to recuse on the implied basis that it was not a reasonable belief. Pursuant to our case law, Judge Elmore is to be afforded discretion in that regard, and I cannot say that she abused her discretion in this instance. Well, that didn't sound like it was overturned. So, why does it say it was... I cannot agree with the majority's conclusion that Judge Elmore's denial of Ferguson's attempted jury trial waiver equated to an acknowledgement that her impartiality had reasonably been questioned. I can't be wrong. I know I saw that. I know I saw it where it said, oh my gosh, this is not my day. Right up here it says, okay, well, let me just read you the opinion summary, because this is where it says, I don't know why it wasn't saying it in the body of the paper, but after a jury trial, defendant was convicted of second-degree domestic battery. Defendant was sentenced to 5 years incarceration with an additional 1 year enhanced penalty for committing the offense in the presence of a child. Defendant appealed, arguing that the circuit judge abused her discretion by denying defendant's motion to recuse, and when she denied defendant's waiver of a jury trial. The Supreme Court reversed, holding that the circuit judge abused her discretion by not recusing because under the facts of this case, the judge's impartiality reasonably could have been questioned by the defendant. And the mandatory provisions of Rule 2.11a of the Arkansas Code of Judicial Conduct required her to disqualify. End quote. So yeah, that the Supreme Court ruled in the favor of the defendant on that one. That's pretty embarrassing for Judge Elmore, I would think, right? Anyway, there's one more case I wanted to go over real fast, and it's just because I'm not going to go over the case. I just wanted to talk about it a little bit. Apparently, there was a state trooper or state police that shot and killed a 17-year-old boy during a traffic stop. And the day before Judge Elmore was going to even give her verbal order on whether or not this the records for this case was going to be sealed or not, she sealed them the day before she even went to court and gave her ruling on it. I mean, the bias is freaking insane. She doesn't even try to hide it, you know? I mean, I don't get it. But she sure has a soft spot for rapists, right? I mean, 17-year-old rapists. If the younger they are, the more sympathy she has for them, apparently. Okay, let's see what we got here. Keeps coming up with California. I never once put California in here. What in the actual fuck? Judge Elmore, South State Police shooting court records. Okay. That's it. Just a picture. Alrighty. Backpack, backpack. I don't know why I have that song in my head now. Jesus Christ. And, you know, we all know that the Supreme Court overturned her gag order on the Aaron Spencer case. So that's two right there that were over, that the Supreme Court shot her down. So it's like, is it normal for judges to have that many questionable verdicts or rulings in there? Oh my God, this is another one of those things that's going to make me subscribe to read the frickin' article. Are you frickin' kidding me? I don't get it. I just want to read an article. Is it that hard? Why do I have to subscribe to your frickin' newspaper just to read an article? It just doesn't make sense. I found an article on it today, but now that I'm thinking about it, it might have been the same newspaper that wants me to subscribe in order to read it. I didn't go far enough into it to know, but now I'm thinking that might actually and apparently they only have one newspaper in the county, because that's the one that keeps coming up every time I try to click on something. It's like, Jesus Christ. Okay, I think I found something. And this will be it. Okay? Okay. Backpack, backpack. I don't know why I have that in my head. Mm-mm. Gosh, darn it. Just when you think you got a fucking grip on what's going on, and it all just goes to hell in a handbasket. Right? I don't get it. I don't know what happened to all my options. It's like, I don't know where they went, but it's not working for me. Share screen. And now, can I just show the nothing but the article then? Will that help? No, it isn't working either. Cancel. Okay. Yay! I figured it out, I think. Let's just take me off the screen altogether. How's that? Okay. I don't know. Is this the wrong one? Oh my God. Did I close it? That's not it. Lord. Okay. And then I promise this will be it. And you won't hear from me for a couple of days. Okay. Lonoke County judge seals case against former deputy accused of fatally shooting a 17-year-old. Lonoke, Arkansas TV, or KATV, sorry. The case against the former Lonoke County Sheriff's deputy accused of killing a teen during a traffic stop has been sealed by a circuit judge. On Wednesday, Judge Barbara Elmore ordered the case against former Deputy Michael Davis, 30, to be sealed. And there's her, infamous signature that we all have come to know. She must be left-handed, by the way she writes. It was during a morning traffic stop in June 2021 when Davis reportedly shot and killed 17-year-old Hunter Britton. Why does that name sound familiar? Davis was charged with manslaughter in September. He was later booked into the county jail but bonded out, because we all know she likes to bond people out. In November, Davis entered a plea of not guilty, and a pretrial was set for March 14th at 10 a.m. The jury trial was scheduled for the next day. Is that it? How come? Okay. Britton's family and friends have regularly demonstrated outside the Lonoke County Sheriff's Office, demanding more details on the shooting. Britton was eulogized by the Reverend Al Sharpton and two attorneys who represented George Floyd. Are you kind of getting the underlying message here? I don't want to have to say it, but obviously they're trying to send some sort of, encrypted message to us. They said the teen's death highlighted the need for interracial support for efforts to reform police practices. As if we don't have enough crap going on in the world. We got shit like this happening. So, yeah. And I don't think he ever went to trial. I don't know whatever happened to that. I'm going to have to look into that and go down that rabbit hole and see what I can find out. But yeah, I don't know why. Oh, because the day before she was going to give her ruling on sealing the court records for this case, she sealed them. She she sealed them the day before she even made her ruling in the courtroom. Is that legal? I mean, how can she do that? Doesn't she have to wait for, I mean, I don't know. Anyway, I know the judges are untouchable. And we live, this is them, and this is the world, you know. So apparently they have no one to answer to, I guess. That's the only thing I can think of. I don't know why. That can't be him. Because this kid isn't black. So that doesn't even make sense. Does it? I mean, right? The kid was black. Yeah. So I don't know. I'm going to have to dive a little deeper into this one and find out what is up, what's going on, because this kid here isn't black. So there's the former deputy, but it says Hunter Britton left in a family photo. That is him. So I don't get it. Why were they making it sound like he's black? That's weird. Right? Why are they talking about interracial police and interracial treatment? This kid's not black. He's white. I don't know. I'll have to do a deep dive on this and find out a little bit more about it. But anyway, she sealed the court records the day before she even made a ruling on it in court, which I found a little strange and a little sus. But anyway, so that's about it for tonight and part 2. I hope I did a little bit better tonight than I did this morning. I can't use being tired as an excuse. So at least it wasn't as big of a fuckery as this morning was. But I appreciate anybody that joined us, and I hope you guys stick around to see what I can do, because I think I can really make a good channel out of this as long as I try. But I just need you guys to give me a chance, give me an opportunity, be patient with me, and so on and so forth. So I will see you guys later. I hope you have a good week. If I don't see you before the end of the week, be safe. I don't know where you live, but where I live, it's raining. So if you have weather in your area, drive safely. And I will talk to you all soon. Thank you. Bye-bye.